to say hello. Yes, we are live. We are live. We are live. JR, hello. How are you?
Good. How are you?
I'm good. You
Because I
said
haven't
you're.
talked to you yet.
I know we haven't even. We just hooked up. Actually, we were talking for a few minutes. So just to be honest, we talked about his Eagles having won.
Yep.
I hear
Go
some
birds.
a little feedback there. Just so you know, his
For
team.
me?
I think so. At least I
Oh,
did
it's on
once.
your end.
Okay. Well, I don't know. Maybe so. Maybe not. Maybe so. We'll find out. Can you hear me okay?
Yeah.
Okay. So JR was talking about the Eagles having played in Brazil and won. They beat the Green Bay Packers, and the quarterback for the Packers got hurt at the very end of the game. I think literally with 10 seconds left. I don't know the extent of the injury. We were talking about how the NFL is such a great league. By the way, that is opinion only. Do not rely upon any expressions about the NFL that are coming forth from this channel. Obviously, do not rely upon anything that is said here.
I
Opinion
didn't say
only
they
at
were a
best.
great league. I just said they're a juggernaut and very business and institutional focused.
All right, whatever. Do not rely on anything we say. It's opinion. Do your own stuff. Just hopefully it has some entertainment quality, or else it just occupies time and space somewhere. We're going to talk about a few things today, of course, besides the Eagles, who are so fine, right? They have an undefeated season so far, right?
Oh, he sprained his MCL, market watcher.
Okay,
Love is
thank you.
out 3 to 6 weeks with a sprained MCL. See, I didn't know that because I fell asleep in the middle of the
Yeah,
third
it was like
quarter.
the last 10 seconds of the game. Like the last
That
10 seconds.
sucks.
Yeah, it does suck. Not a great way to start the season if you're the Packers. Anyway, so please do your own research, whatever, yada, yada, yada. We're just yapping here. We're going to talk a little bit about a bunch of other stuff besides gTII, which of course we're going to discuss. But before we get to that, because gTII stuff is so exciting, I know. Before we get to that, anything you want to talk about? By the way, I don't usually ask you. I usually kind of just throw a bunch of crap at you. But anything that strikes you?
I mean, I don't have anything specific I want to say.
Did you hear about that? Did you see that shooter in Kentucky yesterday? There was
No.
some guy who shot a bunch of people along in Kentucky along a highway, and now he's hiding out in the woods. They're trying to track him down. And it was a
No, I
guy who
didn't.
bought I guess some kind of semi-automatic, whatever. That's probably every rifle. Semi-automatic rifle and 2,000 rounds yesterday. 2,000 rounds. That's serious. Anyway, that's ongoing in Kentucky. I thought that was interesting. Out here in California, it is very hot. It's I think the high where I live, it's about 103 today. That's
Oh
warm.
God.
Even in Philadelphia, that would be warm, or Pennsylvania, that would be warm, right?
Uh, the middle of August. That's about what it is here with the humidity. It was a nice day today. It's Indian summer is hitting. So
Okay, very nice. Before I get into let me give you a brief description of what we're going to talk about. So we're going to talk about horror movies, which JR apparently hates, and he'll tell us why. We'll talk about the coming up debate and maybe election and a little poll stuff. And by poll, just so you know, so it's not confusing, I don't mean Polish, because some of you know that my parents came from Poland. So when I reference polls, it might be confusing. So I hope that clears up something. We might talk about Alpine, because I can give you an update about Alpine. We might talk about the ethics rules for the Supreme Court and maybe insider trading of Congress, because I just find that a really interesting subject matter. And of course, we're going to talk about gTII. We'll talk about the order, the current status of the order, because people are interested in, and what's going to happen after that, and in the action that they brought against me. And again, just kind of like, I just like to throw this out. So if there wasn't an action against me, like tonight, I wouldn't be talking about the 3 documents that I filed against them and now tell you, because I want them to know also, because part of the reason why I'm doing this, of course, is to let everybody know what's going on, but 2, I'm telling them. So if they don't know, if for some reason they're confused, I'm trying to clarify it for them so they can make the right decision. And for example, get rid of my case. That's an example. So when I go over the documents today, because they haven't done that, that's something they're allowing. It's kind of completely in their control. I don't understand it. If they had like a great case, let's say this was NVIDIA we're talking about, and I was bitching about management of NVIDIA. I mean, it's kind of a silly argument, right? Based on how they did. Well, I don't think they performed like NVIDIA, so their position might be a little different. So anyway, we'll discuss that too. Of course, before we start that, I wanted just to throw out a couple things. Do you know that you can make a walnut laugh by cracking it up?
No, I didn't.
Okay, that's good. Good. I'm glad you know now.
Was that the punchline?
That was. That was. That was. At least this is better than the joke. Hey, whatever. How many eggplants does it take to paint a house?
I don't know. How many eggplants does it take to paint a house?
0. Eggplants only paint portraits.
Oh my God.
What are twins' favorite fruit?
I don't know.
Pears, of course. What type of coffee? And this is a test of age, by the way, and we're almost done. What type of coffee was the favorite drink on the Titanic? You have to have a little age here to understand this joke.
I don't know.
Sanka.
Yeah, you do have to have age,
right? Sanka
That's
was
going
a drink.
way back.
Sanka was a decaffeinated coffee-like product.
Yeah, it was decaffeinated instant coffee, if I recall.
Yeah, and last but not least, where do peanuts go to hide?
I don't know. M. Casey says, let's all leave in protest. Yes, let's, M. Casey. Let's all leave in protest.
You ask, where do peanuts...
Me included.
You ask, where do peanuts go to hide?
No, I didn't. You did.
Of course, at the Shell station.
Jesus Christ. That's not even a question I would come up with on my own.
All right.
Market watcher, 3 was enough.
All right. Before we go to the more substantive thing, one thing I said we would cover, and again, I'll if I say we're going to cover it, we'll cover it to the extent we can get to it. We're going to cover like a list of like top 10 or 12 horror movies of all time, or that have been categorized that way. I asked JR about it. I don't know. Tell me your story here, JR. I don't know the story.
So I don't. Well, it's not that I didn't want to share it with you. I like to be a little bit more spontaneous than that. So I don't like horror movies. I don't care for them much. I had 2 really bad experiences watching horror movies. One when I was like 7 or 8 years old. It was a movie called Dark Night of the Scarecrow. And I'll give you the premise. It was about a teenage boy, and I think he had like a cerebral palsy or multiple sclerosis issue, and he was bullied. And the 3 kids bullied him, and he one night he was being chased by them, and he hid in a scarecrow, like in a cornfield. That's where he was hiding from them, and they found him and killed him. They thought they killed him. I don't know if they ever did, because I couldn't watch the rest of the damn movie because I was so freaked out. Well, he ultimately turned the tables on them and went after all these 3 boys. And it was the scariest damn movie I'd ever. I mean, I was 7 or 8 years old. I don't know why my parents even let me watch the damn thing. was so freaked out when I went to bed, and it was a thunder
That
and
might
lightning
tell you what.
storm.
That might tell you a little bit about what your parents thought about you.
I was 7, 8 years old. Terrible storm that night. We watched this movie. I went to bed. I don't think I slept a wink, and I never watched a horror movie again. All the way up until I was in my late 20s. Someone was talking about this movie called The Ring. Got to watch this movie if you haven't seen it, because it's
I've seen it.
damn scary movie.
Mhm.
So me, like a dumbass, I'm staying at this massive house. I was in law school, was doing my clerkship down in Delaware, and the folks that I was staying with left for the night. And I thought, well, I'm going to rent this movie and see what all this hubbub was about. Damn house was out in the middle of the woods. I was by myself. Put this movie in, and I watched the damn movie, and I didn't sleep a wink that night because I kept hearing shit going on outside the house all night. And that was the last horror movie I watched, and that was 20 years ago.
All right. Okay. So I'll give you like a list. One that I didn't list, but I think is like super frightening, is called Jacob's Ladder. And it
That's not a horror movie, though.
You know what? I'm gonna like combine things because
that's not a horror movie.
Richard. I thought it was pretty intense. I thought it was pretty intense.
Sure, I've seen that. I've seen that a bunch of times.
You didn't think that was intense? That's Tim Robbins, right?
Yeah.
Yeah. I thought that was pretty intense. Yeah. I didn't put that in the I excluded that, but that's a movie I think of a lot when I think of horror. And I didn't put this list together, so I amended it a little bit. It might be more than just horror, but I'll just quickly go through it. The Shining. I don't know if you've seen that. Classic Jack Nicholson, right?
Yep.
Okay. During my time as a teenager, this was by far The Exorcist. That came out when I was probably like a mid-teen.
Yeah.
And that was, and they also, when they would advertise, this was funny, I thought at the time. Again, they had newspapers, whatever. So when they would put out certain movies, they would put out an ad in the paper, and in the ad they would say there's a doctor in the back of the theater just in case somebody passes out from the movie or whatever, just to kind of add a little spice to it. Yeah. Exorcist starred Linda Blair, and she, as it turned out, I wasn't good enough to play real baseball, but I played a lot of recreational softball, and I was a good softball player. And I was on a team, and she was dating a guy on our team, and she would come out to our games, but she never turned her head around 180 degrees. It's kind of pissed me off, to be honest. Next, Psycho, classic. Halloween. Have you seen those? Psycho, Halloween?
I saw bits and pieces of Psycho. I've never seen Halloween.
Okay. The Old Bride of Frankenstein, kind of a classic, which would be Frankenstein, Dracula, the Wolfman, and all those. And I can imagine for their time, let's say in the 1930s, that was probably pretty dramatic, and sure, probably would scare the blank out of you. Movies were new. They were talkies too. So I would think those were impressive. Alien. You ever seen an Alien?
Yeah, just watched it when we were down at the beach. My son and his best friend decided to put it on, and they laughed during the whole movie.
Oh, really? Okay.
Yeah.
I just saw with my youngest son, I saw the whatever Alien movie just came out, and right, it was obviously at a much lower budget, I would say.
Oh,
that's where I'll leave it. Jaws. They put Jaws. So again, that's not a horror movie, but it's whatever. You saw that, obviously. Silence of the Lambs. You saw that?
I wouldn't think that's a horror movie. I saw that in the theater.
I thought that was great, by the way.
Classic.
The original Night of the Living Dead. Have you seen that one?
No.
Oh, that one is great. Black and white with zombie. It's kind of like the first real zombie movie. Zombies.
That I know.
A spoiler alert, like the main hero, it's the irony. The main hero gets shot right in the head at the end of the movie. So it kind of ends.
In the 1930s.
Yeah, he's the good guy. That was a classic. Rosemary's Baby. Do you ever see that one?
No.
That, again, another I think well done. Texas Chainsaw Massacre.
I've seen bits and pieces of it.
Yeah, a lot of people who watch Texas Chainsaw Massacre have seen bits
no pun intended.
pun
No pun
intended there.
intended.
Nightmare on Elm Street. That's Freddy Krueger. And a one that I've seen that I think is really good is 28 Days Later. I like very much. It's a more contemporary one. Anyway, all right, throwing that out. Next, let's go on to the presidential debate. It's coming up. Am I putting you to sleep already?
No,
it's coming up.
It was
it's
a long
coming
day, man. It was a long day.
Any opinions about the debate?
Well, I'll tell everybody what I told you. I don't watch the debates because my blood pressure gets boiled. Because I think both sides have done nothing but politicize the debate. That they both sides look for, sound bites and that kind of stuff. The last debate that I watched was John Kerry versus Bush Jr. Back in 2004. That was the last debate I watched. I don't even watch the conventions anymore because I think they're a royal waste of time. So yeah, I will read about it the next day on a variety of news sites. I'm sure I'll pick up a lot on Twitter and Reddit, but I can't watch them. So
okay, fair enough. I would generally agree with you 100%. This cycle, I was kind of interested. I think as I told you, I watched the Biden-Trump debate because I was interested to see if Biden could compete effectively. I got an answer, I think, as the rest of the world got an answer too. And for this debate, and by the way, I'm voting for neither. So that's my view going in. So I have no particular horse in the fight. I'm more interested because I was interested in first to see if Biden was really gone. I understood that now. And I want to see in this debate whether Harris can compete with Trump. That to me would be like really decisive. If she's perceived to kind of hold her own, not win, but hold her own. If she wins, that's a different story. But if she can seem to kind of hold her own, I think that would be positive for her. But I don't know, but that's kind of the way I would. And I'm interested to see how it goes. It's also interesting that they can't interrupt. The mics are off because I heard that in one of the 2016 debates between Trump and Clinton, where there wasn't that option where they could just keep on talking, that when they looked at the reaction, Trump was pretty aggressive and he was kind of like talking over Clinton on one particular debate. I don't remember how many they did, but when they analyzed how it came out, it was negative for him. It was perceived negative, so that there's not his ability to kind of jump in that might end up being beneficial to him. Yeah, I don't know. It's I told you, they used to be, the people are suspect of polls, and I am too, because I don't have any idea. I mean, I understand polling. I took stat. I'm decent in math. I kind of get the idea, but I don't really know the questions that are asked. Because that's really a lot. In a lot of respects, it kind of depends on what you ask, because what you ask will generate a particular response. And I don't know. And I don't know. I doubt if every polling agency is the same. They're probably, some are really good, some are not so good, some may lean right, some may lean left. That's kind of the way I perceive it. So I take it all with a grain of salt. Last time I used to look at 538, which was I think it's Nate Silver's company, but he sold it. And based upon my discussions with some people, they find it currently not as accurate as it was in the past. And, was it accurate? I don't know. So I look at real clear politics. I kind of follow that. That's kind of an amalgamation of a bunch of polls. So it's supposed to be more of an average. But you don't know which polls maybe should be really given like a higher weight than other polls. So it's still not 100%. But I looked at that and I kind of follow it. And I'd say the trend is last week it was Harris, and this is like a national poll. And I think you would agree, JR, do you agree with me? For the Democrats to win, they have to win the popular vote by at least a couple percent. It doesn't work if it's a close popular vote, because that translates to losing those states they need to win.
Yeah.
So yeah, so it's generally
Yeah.
perceived that they need to win the popular vote by at least 1 or 2%, if not more, because they won't win the electoral college that way, because they'll lose, states like Pennsylvania, whatever. Because like, my guess is like in states in like New York and California where I am, the margins will be big and it'll be
Yeah.
big numbers. So that kind of distorts kind of the picture a little bit. Especially if the vote is close. So last week it was 1.8%, the average Harris ahead of Trump across the board, not any particular states. And this week it's 1.4. So that's a significant change. And I wouldn't be surprised that how the outcome of the debates might impact that. And with regard to those states that everybody thinks is going to decide, like where you live, right now, the way they set it up, the difference is 0.1%. So it's really not determinative. But what I found interesting, and I don't know how this is going to play out, was the difference this year compared to prior years where the Republicans and the Democrats stood. So for example, in 2016, on this date, where was Clinton? Where was Biden? And where is Harris? Those numbers were interesting. And Harris does not have the strength in the numbers that those have. But then I throw out, but then it's not the same setup. She kind of came in late. So
well, the other thing you got going on too is I don't think the polling is accurate anymore.
Oh, I agree. I agree.
I don't think it's been accurate for a while. If you
agree.
go back to polling with Clinton and Trump, his first run, which obviously he won. I mean, all the numbers were pointing towards Clinton, and some of them were big, and she ended up obviously losing the states that they weren't paying attention to. Pennsylvania was one of them.
Yeah, I'm not even.
I will tell you, I think it's going to be close in Pennsylvania. I think it's going to come down to maybe a difference of 10,000 votes either way. Could 10,000 for Harris, 10,000 for Trump. I mean, in the area that I live in, this is a very conservative area in central Pennsylvania, and I don't think Harris has the level of excitement that they're talking about online. I just don't believe what you're seeing with Twitter and what you're seeing in the news. I just don't see her having that level of excitement here in Pennsylvania. And I personally think Pennsylvania is going for Trump. So as if they don't.
Yeah, my point was I was just looking the most important of what I was saying, and I don't know if it's important, by the way. So I'm withdraw what I just said. Was the relative strength of the candidates, of the Democratic candidates from election to election, and clearly Harris does not have the strength that the prior Democratic candidates had, but we also had like a much screwier path that she took to get there. So I don't know if that influences those numbers and which way it does. So if you just looked at the numbers, clearly she doesn't have the strength that the prior cabinet. But she got involved much later, and again, I don't know if that skews the numbers. So it's confusing to me.
Well, it goes back to something I said 2 weeks ago when I obviously took all that heat for my kind of outburst. But the Democrats do not have anyone with any real charisma. I mean, you can say what you want about Trump, but the guy has charisma. Obama had charisma. Biden did not. I get it. Clinton had charisma. Even Hillary had charisma. Harris does not. I just don't see her exciting people the way those other politicians did and do. I mean, Clinton still continues to excite people. Obama still continues to excite people.
You're right.
Obviously, Trump continues to excite people.
Some people have charm. Yeah, some people have a charm and ability to motivate and influence people.
And so it comes down to the independent vote. And if the independent vote, if they look at the candidates, it's going to come down to who they're more excited about. That's my personal opinion. Which one excites them more? Does Trump excite them more by what he's saying, or is Harris exciting them more by what she's saying? And I don't hear anything exciting out of her.
Yeah.
She just does not. She doesn't do it for me.
Yeah, my view is like, 200 years from now, when historians are looking back at this particular election, they won't conclude this was the best slate of candidates, is my conclusion. And that's just kind of how it is. So to me, this particular debate then is might be influential until terms of the outcome, because if one of them gets squashed, that's probably enough. That's probably enough to make a difference. And it's very possible. I would think Harris should be a good debater, because if she actually was a prosecutor, which I believe she was, then part of the skill of being a prosecutor is being able to talk and take an issue, present an opinion, and then when the other side gives a contrary opinion, to be able to respond to the contrary opinion right at the moment and give a coherent response. So I would think she should be good at that. I would think.
Well, we'll see. I mean, the stakes are 1,000 times higher than standing in front of a jury and talking. The other thing too is these folks are so well prepped. I mean, that's all their work. That's what they're doing right now. That's what they should be doing right now. 24/7 is debate prep. I don't know. I have a love-hate relationship with politics. I used to love politics. That's what I wanted to do when I was in college. I mean, my very first memory of politics, you're gonna laugh, is sitting in a house right here in my hometown. I just happened to get sick that day. I think I was 9 years old at the time, and I was watching a cartoon called Grape Ape, and it was March of 1981. And I was watching this show, and newsflash came on: President Reagan had been shot. And I was glued to the television from that point on, because I was like, what is this about? You know what I mean? Like, I had all these things going on in my head with this. And, from that point on, I just remember very much being attuned to the news and being attuned to Ronald Reagan, and very much loving Ronald Reagan. And I read books on him in college and wrote papers on him in college. And, he really was the great communicator. And I think after Reagan left office, we lost that. Reagan was at a whole nother level in terms of an effective politician. And I don't think we've had the likes of him since. I don't think you can say that about Clinton. I mean, Clinton was a master politician, but I think he was more of a master schemer than he was politician. Reagan was able to bring people together and talk across party lines. Hell, if you read anything about Reagan, one of the things you'll learn pretty quickly is him and Tip O'Neill, who was the Speaker of the House at the time and a staunch Democrat, obviously, were actually good friends and would have bourbons together on the weekends. And they made it a point to have lunch together. We've lost that. We don't have that in this country anymore. Politicians reaching across the aisle and truly working together and truly being an institution of Congress. Those days are over. We have the left, we have the right, and they do not want to meet in the middle, come hell or high water.
By the way, so the I'm sorry, I didn't.
No, and so that's where we're at in terms of our politics, and we're we're never going to see another politician like Ronald Reagan. That's my personal opinion.
Well, so just a little personal local flavor. So the Ronald Reagan Library is 15 minutes from where I live.
Is it really?
Yeah. Whether you like Reagan or not, it is great. It is really a great, because I've been to the one in Dallas. I've been to a few, and I think the where he is located, because on a hill, you have a view, a beautiful vista. It's a big property. He's buried there with Nancy. You can pay an extra fee to go into the crypt to say hello. Did you know that?
Oh, really?
Yeah.
No, I didn't.
Yeah. It's got an Air Force One in there. It's got like a bunch of vehicles. They have great exhibits. Like at one point in time, if you were a baseball fan, they had because Reagan was a big baseball fan, and he did recreations. What a recreation is, like the game is going on, but you're not there. So they would have literally a telegram going, and they would read the wire, and pretend like they were calling the game live.
On the game.
Yeah. So he did that, and they had an exhibit there where they had a traveling exhibit from the Baseball Hall of Fame that was there, and it was great. And they have great exhibits. Right now they have a Star Wars defense exhibit, but literally Star Wars part of it, like the the movie, but defense also. Anyway, if you're ever around in LA, I highly recommend going to the Reagan Library. I mean, I've never heard anybody who had a bad thing to say about it. Really interesting to see.
I love all that stuff, whether it's Trump's library, Reagan's library, or Obama's library. Anytime I have the opportunity to stop in and see one of those places, I absolutely would.
Well, that's what, that one in particular I would highly recommend. And again, I've never heard anybody say anything bad, except for JR. I'm going to skip for now the ethics rules. So let's get to gTII a little bit, unless you wanted to talk about anything else before gTII.
No, I think you need to get to gTII. Hell, it's 8:30 already.
Oh, wow. So gTII. So what has happened since our last conversation? Our last conversation, I think we talked about, I was going to file a Rule 11 motion. We talked about the order, the original minute order from the court, and we talked about what was going to happen. So now let's talk about what has happened in the 1 week. So in the 1 week. So that minute order was converted to a proposed order. So the attorneys who are representing us, the shareholders, prepared an order. The order itself is 21 pages long, so it's very detailed. Part of the order is the findings that were reflected in the minute order that we talked about last week. Like, right. For example, just for example, failing to file its required disclosures with the OTC and SEC, causing gTII to become delinquent, those kind of things. So those are referenced here, and then all the powers and what the receiver, if appointed, can do. Now, the receiver, if appointed, acts at the behest of the court. So anything the receiver does of any kind of significance has to be run through the court. But the order permits the receiver to engage in certain kinds of activity. So number one, and the way this goes, it was presented, it was passed around already a few days ago, waiting for defendant to respond. Eventually, it will go to the judge, eventually being this coming week. If there's any changes to be made, the court can make any changes they want if it's appropriate. But the very first thing is to make it, that's referenced in the order, talks about bringing gTII current with its filings, for example. So the way it's set up is it's known that getting whatever delinquencies exist has to be dealt with first and foremost to make sure that gTII is in compliance with whatever requirements they are in need to comply with. We know that's the case because if you look at the OTC Markets website, it says SEC delinquent in their filings. So that right. Gave me a hint that that's what they are. So the first thing would be to get rid of the filing, and that's really literally what the first thing is talked about, is get the filings current, obviously to get it tradable, because it's not tradable. We see it. Some people, I think, can trade it, but the volume is usually really small. And if there's a real volume of tens and hundreds of millions of shares, I haven't seen anything like that traded. So it's not really done. And then the next step would be to take over control over all the assets of the company and conduct business. That would include also to pursue collection of whatever shares need to be collected, whatever assets need to be obtained, and to initiate or conclude whatever litigation that needs to be done. That should include me, by the way. That litigation that needs to be get done. Now, the way I think there's the way it's reflected in the order the receiver will get compensated based upon actually bringing in either assets being real property, Bentleys, ice cream, whatever. If they bring in that stuff, the way I read the proposed order, they would get 10% of the total that was brought in. I thought, if you're an attorney, on a contingency, you're going to take like a 33% of the minimum, and you might take longer. So I looked at that and I thought, okay, so if they go out and they chase down the assets and they bring it for the benefit of gTII, and they bring in, $10 million and they get paid $1 million, 10%, I think that's okay. My view. The court might think of it differently, but the judge will ultimately decide if that's reasonable or not. But in my mind, it clearly is reasonable. It gives them a certain incentive. We have no incentive. Part of this deal was getting rid of management, which by the way, one of the powers that's reflected in that order is the receiver can get rid of all management officers and replace them. Right. So that means everybody who's existing there today, whoever that is, may not be existing there as soon as that order is done. Because I expect complete clean house.
Has the order come back from opposing counsel?
No. I sent out an email to our counsel asking that, and I did not get an affirmative. So not as of Friday or Saturday this weekend, whatever. But anyway, I think the same thing applies to stock and cash. So to the extent they're able to bring back stock or cash, again, it's 10% of the value. And since the value of the stock right now is kind of low, it's probably a very good bargain. Cash is cash, whatever. But cheap stock, this may be stock that, and again, I don't know. This is not an opinion, whatever. But theoretically, according to the current CEO's contract, if the stock goes up to $2, that's a bonus number. So he must think that's a possible number. So I just kind of throw that out for whatever it's worth. It's certainly not that now. I don't even know what it is. 3 cents, 1 cent, 2 cents, whatever.
Somewhere around there.
Yeah. Yeah. Without being able, to be honest, without being able to get back to a tradable status, it's not anything unless you recoup those assets. And then,
it's 0.013
is, yeah. Okay. If you recoup, millions of dollars in assets, then that just recapitalizes the company, and then we start over. I don't know when the company had that much in actually assets, to be honest. So theoretically, because the way it works is, let's say, and I don't know if this is true, by the way, so this is just me talking out loud, but let's say over a long period of time, somebody took a certain amount of shares or distribute them that they shouldn't have. But it didn't all happen in one moment. So maybe the accumulation of is a lot, even if not in one moment. We know, like, for example, we remember that they had that distribution January 25th, 2023, which is about 66 million shares. That's a lot.
Right.
I don't know if there was ever a 66 million share distribution, but there might have been other ones. So what's going to happen is there will be objections filed to some of the language. Who knows what they'll object to, but they will. Guarantee you they will. Then the judge will decide, is that BS or not, whatever. They will probably appeal, my guess is, because they have there's no benefit. If they just let it go, they lose a lot of control. I'm guessing they appeal, but they would have to post a big bond to get a stay. So They may not. So what's going to happen is order will go back to the judge. Judge will sign off. This order asks for the specific appointment of the receiver. So if the judge signs the order, that will include appointment of the receiver.
So let's go back a second. Let's go back. So right now, the proposed order that plaintiff's counsel has drafted,
Our counsel, yes.
Our counsel is with opposing counsel.
It also went to counsel for the proposed receiver.
Oh, okay. So
yeah, the proposed receiver has counsel too.
Right. So you got two separate parties happening.
Correct. So I think the way it is, they drafted it, they sent it to receiver counsel. After receiver counsel approved it, then they send it off to defendant's counsel. That was at least a few days ago.
Okay.
Generally, it's like a week. You figure you have to review that kind of order and comment. Right. So I would expect it sometime middle of the week.
Well, they can't sit on it. They can't sit on it. So they have to review it and send it back.
Yeah.
My question is, which I'm sure as other people are thinking, how many times can this go back and forth?
It may not go beyond this.
It may be like, that's what I'm getting at.
Yeah, listen, if you recall, and you could look at just by, we kind of went through that minute order. The judge kind of is inclined, right? We kind of know where the judge is inclined. So if they try to, and by the way, in the order, and remember, if I raised this was an issue, and this could be again an issue in anybody having another stock that's based in Nevada that wants to move against the company because of a purported breach of fiduciary duty by the officers that harms shareholders. So we talked about this, that there was the 10% requirement. But in this order, for example, and even with the minute order, the judge said there were 4 bases or bases. Basis or bases?
I never know.
There were 4 grounds for appointing the receiver and permitting the TRO. One was the 10%, only one of them. The others didn't require the 10%. And if you recall, part of what we talked about was this will become, because it is according to the way the statute is written, this will become precedent if it's granted, because the way the statute says, it's cases in Nevada where these type of orders have been granted. So if it's granted, then somebody in the future can now say, well, this is a type of case where it's been granted. So it will fit within the statute. So I feel comfortable now because the way, and I had, by the way, I definitely discussed this. And I said, it wasn't specifically brought up. It came up during the hearing, but it wasn't a main point. But after the hearing, I said, I really hope that the judge expands the receivership beyond just that 10%, because then it completely nullifies the argument. Because the argument at that hearing on the receiver, they spent 70% of their time talking about that 10%. They bitched about the way it was calculated, what it should have been calculated. They really didn't have an argument about, because what they did is they literally presented a declaration from everybody who was a shareholder.
Right.
And it said, I have 5 shares and I'm committing them to the cause. They really didn't talk about that. They argued about like the specifics of what kind of shareholder, that it could be like a benefit. We talk about if it's in the name of your name, or is it in a street name, right? How is it being held? Is it being held in your name, or is it just being held in the brokerage's name? And they were distinguishing between those. So, and that was their primary argument, really. Well, that was because they were arguing that there's no jurisdiction. So if you don't have 10%, get out of here.
So that's what they're going to argue on appeal.
Yes, that will be argued on appeal. But because the judge has asserted 3 other grounds for it, it's a loser. It's a losing argument. And I'm grateful for, and again, didn't come up during the hearing, but I definitely discussed it. I'm grateful for the judge who was on top of the really. I thought he was on top of things. I said it before he ruled. So it's not like just because he ruled, if you go back and you listen, I said I thought the judge listened to everything, was thoughtful, and I didn't know how he was going to rule, but I thought I was impressed by him. So he's followed that up, and he's been thoughtful in his ruling, his minute order, and this is how now it's going to be expressed by the court. And then the receiver will take over.
Hey, let's address some questions. I'm seeing the same question that we saw last week. So who's the proposed receiver?
Paul Strickland was in the order.
Okay.
I don't know anything about him. When I spoke to our current counsel about him, he had nothing negative to say about him. They haven't done a whole bunch of things. He thinks he's qualified to do the role. And, you know, again, my view is I haven't seen anything to the contrary. If the court, though, is bothered, then they'll put somebody else in. Okay, whatever. I don't care. To me, it doesn't make a difference. We do remember in the court's minute order, though, they said nobody from management could be the receiver. So listen, as long as we know it's nobody from management, then whoever it turns out. And again, the point is the receiver works for the court. If the receiver does anything that they're not allowed to do, the court has power to go after the receiver. It's not like the receiver is acting independently.
Right.
So,
So
and so I've been involved. So it's not now, not in securities cases, but often in a either like a commercial real estate situation, multi-housing, whatever, where there's rents coming in and there's some dispute that arises. You need a receiver to come in and operate the business. So I've been involved in plenty of receivership actions, and I've never been involved. You know, anything can happen, but I've never seen the receiver do anything that the court didn't say they were allowed to do. And every time I saw, the receiver asked permission for anything that was material because the receivers know they don't have the power to act without the court. So,
and that's
again, I can't vouch for anybody, but I can vouch for the court. I felt comfortable with the court. I felt comfortable that to the extent the court orders a receiver, the court's going to be supervising that. And listen, between you and I have no allegiance to anybody. So if I see nonsense, listen, don't you know by now, if I see nonsense, I'm going to bring it up, right? So if I see things that I don't think are helpful for shareholders, it will be disclosed. So I can't vouch for the guy, but I do vouch for the court. That's kind of how I look at it. Any other questions you had?
No, but I'm seeing a lot of comments about your jokes.
Oh, okay. I'm sure. That's funny. That's funny. So that's the order. We're waiting for the final order signed off. There may be again, and the bond has been posted. So that was preliminary to the order, to the entry of the order, because the bond was posted as required by the TRO, which is typical, by the way. And the amount was chump change. $5,000 is chump change. So we'll know probably this week more about this. We'll probably see an objection, and hopefully we'll get a court to sign off. Again, if you recall, this judge was pretty busy. He's got a bunch of trials and stuff. So
someone else brought up another question, which I think is an interesting one that we should address. So
sure.
There's a question out there, will the receiver be appointed before there's an appeal? Because the appeal can't come until the order's signed. So
correct.
Yes, the receiver would be appointed. Now, let's talk a little bit about process and procedure, because they can file an appeal and ask that the court stay the decision pending the appeal. Yeah. And so what would the likelihood, well, two questions. Who do they appeal that to? Do they appeal that back to the judge, or do they appeal that to the next level appellate court?
Appellate court.
So walk us through that process.
Yeah, so I'm not an attorney in Nevada. I don't know Nevada law. So, again, like everything else that's said here, especially what JR says, take it with a grain of salt, and don't trust anything he says. Yeah, so we'll go up to the appellate level. What was the other question?
So who did they appeal though to? Did the I let me let we're talking the real specifics here.
Mhm.
If they're going to file an appeal for a stay,
Yes.
pending appeal,
Oh,
who
yeah,
do
yeah,
they
okay.
file the stay? Who do they file the stay to? Is it the
Yeah, so
sitting judge or is it the appellate level?
yeah, so if I'm in California, I'm going to give you the California answer. So in
Sure.
California, I could do one of two things. I could go to the Superior Court judge, which is in this case the judge issuing this order in our case, and I could file an application and ask for a stay. The judge, and I would think about what's the likelihood of this judge granting a stay in light of his order. Probably very slim or none. Didn't seem to like he's inclined. Um, if I thought, though, filing that application might enhance my chances of getting it granted before an appellate court, I still might file it in front of the trial judge just to get him to deny it. And then I could say I tried, and now we're in the appellate level.
Right.
But you can, if not that way, you can go straight to the where you're filing your appeal, and you can ask for a stay. I also don't know if there's some rule in Nevada, although nobody said anything, so I haven't seen it. Like our counsel in Nevada hasn't said it to me. I would think it would be relevant, but sometimes there's statutes that might provide for a stay under certain circumstances. So in Nevada,
Right.
could there be something like that? I guess it's possible.
Right.
Otherwise, you file an application, and there would be like a request. There would be briefing, and then the court would decide. They would probably defer in large part for factual findings that were made by the trial court. So our trial judge, and again, I have to say thank you to our trial judge. He found a lot of factual problems about the conduct of management in the minute order. So that would go, that in essence gets tossed to the appellate court. And when they're making their decision about whether they should issue a stay and also the final decision, whatever that is, they look at that stuff and they're kind of
Sure. They
stuck
look
with
at the
that.
facts.
Yeah, they're kind of stuck
They
with
look at
those
the
facts.
record.
Yeah, they're
It's
not. Yeah, it's not most likely going to be decided de novo. In other words, they're not going to go back and decide, make factual findings about what occurred in the trial court. Now, there are
exactly what I
some
was gonna say.
situations, again, I don't know Nevada law, but there are occasional situations where the appellate courts can look at something de novo, which means they could decide factual issues on their own. I don't believe it's this particular situation, but I don't know. But we will see over the next week this develop. It's going to develop right before us because there's going to be an objection. Eventually, the court's going to sign off on it. Eventually, I think it's just a matter of time. The receiver is going to be put in place. There will be then a battle. There's going to be a battle because I know the receiver is going to want to do the corrective stuff, correct the deficiencies, want to get rid of people that maybe the receiver doesn't think are best suited for the interests of the business or shareholders. At some point in time, for example, for Rabari, the current CEO and COO, according to the way I read his employment agreement, he can get 24 million shares over a relatively short period of time. He's gotten 8 million shares so far. And if the stock goes to $2, he gets an additional 10 million shares as a bonus. So in totality, 34 million shares. That's the way I read it so far. And if it goes to $2 and he keeps those shares, you're talking about nearly $70 million. So that's not insignificant, really.
Oh, a lot of money.
Yeah, a lot of money. So with that in mind, when it comes, if the receiver decides he wants to clean house, and that includes getting rid of Mr. Rabari, and I don't know what the receiver will decide, that Rabari might think that they're trying to terminate his contract and eliminate his ability to get those additional shares. And I would expect that's something probably get litigated. I don't think he walks from that, or there's some settlement. Either like if they say you don't keep the shares and you have to leave, I don't think that, I'm sure he would leave, but I don't think he's going to say, you know, it's okay. I'm just going to walk away from my shares, because that's conceivably a lot of money. So
Yep.
again, either litigation or some resolution, perhaps in the grand scheme of things, we've talked about this. We don't know how this is going to turn out, the ongoing litigation. We know how the Nevada judge, kind of felt about things, and we know how we feel about it, how I feel about it, etc. But we really don't know how it's going to work out. You never know how lawsuits are going to work out. There might be technical problems, notwithstanding the substance. I feel comfortable on the substance, but technical stuff, you never know. So you never know how it goes, and maybe some deal works out. How about if how about, and I don't know any of this to be true, by the way, so I'm not saying this is true, but what happens, we find out one of these guys is worth $100 million, and another of the defendants decides they're going to turn and flip on that person to expose their assets. Well, if that's the situation, then a deal may work out and somebody might keep stock, and you would work out terms much more differently than if they weren't bringing that kind of asset to the table. So I always hesitate to say, how are things going to work out? I've been involved in enough lawsuits over the years to know that it does not, and I know this sounds ridiculous and stupid, but it does not make any difference at the distance that the parties are when the case starts. Makes no difference. 95% plus of all lawsuits are going to settle. That's just the way it goes. That's just the nature of the beast. So why do they settle? They settle for all kinds of reasons: cost, what you get, insurance. Sometimes it's because people will bring something to the table, information to the table that is helpful. And that might be something that causes a resolution or a settlement. So, and I don't know how it's going to work out, but that's why I don't I don't shut off potential things, because I've seen it, and seen it where it doesn't make any sense, or at least didn't make any sense at the start, but it did at the end. And I know, people get pissed off. We went through MMTLP, right? So people, and I understand, listen, I personalize this too. I personalize it more because I don't like shareholders getting screwed. And you and I have seen enough of it, right, in a short amount of time, that we won't accept it from whoever it's coming from, whoever it is.
No.
So anyway, that's why we're here, and we'll see how it works out in the long run. But again, I have confidence in the court, and seems like they've followed through. And again, like I said it before they had issued a ruling. So I did it. I've had plenty of times with judges where I thought, based upon a hearing, that it might go one way or the other, and it might go the other way. So I could have been wrong, but I thought this is a good judge. So I think he's setting up the appellate record, which is where we were. He's setting up the appellate record so it's very defensible in terms of somebody files an appeal. I think it's going to be tough. So that's where that part.
Well, just based on some of the factual findings.
Yeah, I mean, yeah. Based upon the factual stuff, and the stuff that happened since the conduct that against mine, they accused me of defamation. And I know this must bore people at some point in time, but they accused me of misconduct, defamation. And since that, there's been a whole slurry of things that happened.
Yeah.
And the point with defamation is, I could be wrong. It's okay. I mean, the way the law works, because again, we're talking about the First Amendment. That's why it's different than other claims. That's why it's hard to prove up a defamation action, intentionally speaking, because everybody has a First Amendment right to say whatever they want, right? That's we all know it. Now there could be ramifications. Not everything is, purely protected, but in California, for example, you have a First Amendment right just like you do everywhere else, and it is protected. It is specifically protected. So as a result, defamation actions they're not um, they're not promoted, and they're difficult to prove.
Right.
And part of the way it works. So now we're bringing it to me because who doesn't like talking about themselves more than I? I encourage JR to give me like a 10-minute pep talk about how good I am before I start this. He elected not to. He left it at all last week. But so we have the Nevada stuff going on. We have the California stuff going on, which they've elected to go on. So what have I done? I think since our last discussion, I served the Rule 11 motion. Rule 11 motion is a motion for terminating and monetary sanctions based upon either harassing conduct or a frivolous lawsuit. Now, in my case, it's both, I claim. I claim it's harassing because they heard, I don't think this is like a far-fetched, idea, by the way. And I'm not telling them anything they don't know either. Oh, by the way, if you're watching tonight, hello. Again, please like and subscribe. You could say hello too, JR. Yeah. But the Rule 11 motion is based in part upon harassing. So I think they're harassing because they're, my opinion, because I was bitching about all kinds of stuff. I was reaching out, email. I was a pain in the ass. Okay, that's kind of my view. I don't believe, and I'm not trying to take credit for it, but I do not believe we'd be in the position we are today, but for me being a pain in the ass. I believe it was all justified and correct, but I think it was an instigator. So they probably did not like that, is my guess. And that's why they sued me. So would that be harassing? Yes, that would be. But that's kind of hard to prove. So how do you prove that was harassing? And then you remember that 6:30 a.m. on the Sunday morning? Wow. I think that was like a gold mine. I think like that was like because again, it's hard to prove in somebody's intention. But when somebody for no purpose harasses you at your home at a ridiculous hour, I think that's evidence of harassment. So that's part of the motion. And the other part is the frivolous part. And that relates in large part to the merits that everything I said and complained about. Well, first of all, is it defamation? To be defamation has to be factual. So then there's an issue. Is it factual or is it opinion? Again, just because I say it's opinion doesn't make it opinion. But if I lay out a bunch of stuff and I really give you cautionary language, which I do, then it's generally interpreted to be opinion as opposed to fact. A lot of the stuff they say is just not intelligible the way it's presented. Most of it's not in quotation marks. So that's dealing with kind of a procedural way. Then on top of that, there's a California litigation privilege that says anything related to litigation that's discussed is absolutely privileged. So that includes a demand letter. So in our situation, and it's now will be before the court, but also February 6th, I sent a demand letter. I started this whole thing with gTII, with the directors, with both counsel. Eventually, it made it up to Mr. Rabari, where Rabari was included in that list, but that happened much later. But according to California law, when I file that demand letter, that's kind of where we're starting the time clock. Everything that's alleged in the complaint occurred long after that. So according to the law in California, and this is in the papers, so I'm not telling them anything they don't know. This is tough for them, I think. I think this is a loser for them, myself. I think it's going to be absolutely privileged. You know, we've had the opposite, right? MMTLP, when we're dealing like regulatory bodies and they have immunity, whatever. Kind of like this is the flip side. Again, because it's the First Amendment, it gets special protection.
Right.
So, and because they want to, because you can imagine the problem, what would happen every case that everybody was involved in a lawsuit where the plaintiff or defendant accused the other side of being a criminal scumbag, there would be a lawsuit out of every piece of litigation. And so just can't happen. So for that reason, absolutely privileged, I think they lose. So we have a couple of reasons why they lose, and that's Rule 11. But the way it works is first you give it to them. They have 21 days to decide. If they withdraw their complaint and dismiss it, then I can't file that Rule 11 motion.
Right.
So if they dismiss their action, that's the end of the case also. End of the case on my side. At the same, so that's pending. We're about day five or six of the 21 going forward. At the same time, I filed a motion to dismiss. The motion to dismiss, and by the way, that's heard. The hearing date on that is October 31st on the Rule 11 motion. Motion to dismiss set for October 24th, a week prior, and that's based upon in a motion to dismiss, which is called in federal court a 12B6 motion. You can argue about, whether they have claimed enough in their complaint to satisfy the standards. But a lot of times, even if you succeed on that, if I'm challenging the complaint or something, even if I'm successful, the court will let them try again because factual, you could just written it poorly, but maybe there's enough there that you might be able to figure it out. In our case, we've had three tries. We had a letter, original complaint, and a First Amendment complaint. So they've really had 3 attempts. And they've set it out. So I have asserted that what they have said is barred by the litigation privilege also. So litigation privilege, just kind of what we talked about, because it relates to, if you look at the allegations, for example, they are saying, they claim I said they're looting the company, for example. Well, we saw what the court in Nevada said, right? It did say that, right? That was one of their findings. It converted company assets, for example. So we will see how that plays out. But if it's an absolute defense, that means I win and the case is over. It's not a case where they say they can go back and allege more facts. So that would be another way of getting the case over. The third thing that I filed, also set for the 24th, is called an anti-SLAPP motion.
Right.
And again, that relates to speech being protected. So in California, the way it goes, and California has, again, a very broad protection for this. In California, if you establish it's protected speech in the public interest, for example, a lawsuit filed is such, and discussion in a public forum about legal issues or about gTII would qualify as such. So once the court decides that's has been shown, then the burden shifts to the other side to show they would win. So all these are going to go on at the same time. I've given them, I did it on Friday. I think over the weekend, I sent them a demand as a shareholder. I said, hey, you're breaching your fiduciary duty by pissing away gTII money going against Hoffman on a frivolous lawsuit. So stop it. So I sent that out. Now, that happens to benefit Hoffman, whoever that guy is. But also, I believe it's in the best interest of shareholders if the officers and directors of gTII, as currently situated, don't spend a bunch of money on legal fees, because I think according to the way that decision was of the Nevada court, the minute order, there's reason to believe that the expenditure of legal fees would not be necessarily in the best interest of gTII currently.
Right.
So we'll see how that goes. So those are three things that are ongoing. I know that was really boring, but
Exciting stuff.
Rule 11, motion to dismiss, and an anti-slap motion, all ongoing now.
There's some clown in the chat that's imitating William Ferron. Go block this asshat. See, I wasn't going to say anything until you poked fun at me. I was going to let you go and goof off, but whatever.
I didn't see it. Unfortunately, again, like I said, my right eye is my bad eye, so I apologize. And I know because sometimes I see people tell me that there's been somebody in there. Luckily, I'm completely ignorant of what they say.
I said, I was going to let it go. I didn't care. Whatever. People were having a good time, and then he said something about me looking cool and smoking a cigarette and wish he could be like me. Fuck that. Yeah. Don't. You ruined it for yourself, you fucking clown.
Yeah, I mean, yeah, so. I prefer if everybody's nice. Yeah, we don't know actually. Somebody like from gTII might be in the comments. I don't know. I still wonder. You know, again,
Al Rogan says thanks for noticing, JR. That's all I'm focusing on is the comments, guys. I as Richard's talking, I'm reading them. So yeah, I'm always focused on them. Because he can't see out his right eye.
Yeah, I can't see out of the stupid right eye. Here it goes. That's why when I lean over like that, I'm trying
That's why he leans sometimes.
Yeah, when I lean like that, I'm looking. I'm trying to, and it's funny when I'm leaning, I look like I'm going the opposite direction. I'm going actually the right direction. Anyway, so just to kind of recap, we have the order that's going to be final at some point in time in Nevada. We have 3 motions that I filed, and we have a request for them to dismiss the case. There was some discussion at some point in time. I'm not aware of any further discussion. I did get contacted by other counsel, separate and apart from the counsel that I'm dealing with locally. So just to kind of put it out there. So some other counsel I've had communication with. I don't know what that means about their current counsel in terms of their longevity. But like I also said, you know, and this may not be their fault, but you know, if you're the client and your attorney's result is bad, they could be the greatest attorney of all time and you still think they suck. I mean, that's just kind of human nature. That's kind of human nature. My favorite story about that is in my lifetime, I've done plenty of arbitrations, by the way. That's why that MMTL arbitration was so frustrating, by the way. But I've done, you know, like 6, at least in the 3 figures, well into the 3 figures arbitration. And I had one where it was a business dispute, a dissolution of a partnership, 2 partners, they were splitting up their business. It was an interesting business, by the way. It was a design business, and they had designed pavilions for the Olympics.
Okay, so before you go down this path, and I know you're dying to, because you love to talk. Someone asked about, are you gonna talk about what's going on with Alpine? And
yes.
I just happened to notice it's
yes,
quarter after. So yeah.
Yes, I will.
I'm keeping you on task tonight.
Yeah. Okay. I'll. Where did we stop with the Olympics?
Oh my God, we are 2 fucking clowns. There's no 2 way about it.
All right. So briefly, I'll talk about Alpine. So Alpine, I checked today. As of today, the appellate court still has not ruled. SEC has not taken any further action. They're just kind of like sitting on it. I do not know. I do not know what they're waiting for.
Hold on. I got a clarifying question for my own edification.
Yeah.
Are we still talking about the appeal with Alpine where they could use a Jarkessi?
Yeah.
Is that wow? Yeah. That still hasn't been issued.
No.
Wow.
No. And I think the oral argument, I think, was March.
Yeah, it's been a while. My God, we did a YouTube video.
they had like some post briefing, some minor briefing, but basically a long time. I don't know what's taking them so long. But the SEC, you know, the other part was the Utah side of it.
Well,
Nothing's
you had,
happened
well,
there.
you had two
Nothing.
things. You still had the NSCC
Yeah,
forcible
that's what I'm
act.
talking about. That's the Utah part.
Oh, okay.
Yeah, that's kind of like the reason, you know, by the way, and it's in my briefs, that is the precise reason why I started going down the road I did.
Right.
I didn't know. I mean, I was correct. I didn't know I was going to be correct, but whatever, it turned out correct. When I first heard about Alpine, you know, everybody thought it was going to be a short squeeze and a, you know, whatever. And they saw the concentrated short position, at least at that time. And so people believed as they believed. When I first got involved, like everybody else, I believed that too. And
Well,
I'm
sure.
not
That's when
saying,
I pulled you in.
yeah, I'm not saying that's not going to happen, but I have no idea at this point in time. And I have no idea of when you'd be able to predict that. And I have no idea when, you know, I don't know. You know, after all this, I couldn't rely upon that. I couldn't say that with all. No, how many times have we seen it? Very few. Happens very rarely. And in terms of picking a time, I I think less. So that's what got me started on focusing the business aspect of gTII,
Right.
because I didn't think it was the Alpine part. I didn't think it was moving at a fast enough pace.
Well, we kind of knew it wasn't, especially when the case got moved from Florida to the DC Administrative Court. We knew at that point we were looking at
Yeah,
the long haul. And, you know, one of the things that you and I kept on talking about, if you recall, was nothing was happening with the business. You know, we
yeah,
were hearing rumors of all these deals and nothing was going on. Then you, on your own, decided to do a deep dive into it. And I mean, I remember you texting me and calling me, hey, I found this, hey, I found that, hey, I'm doing this, hey, I'm doing that. And, you know, at that point, I obviously didn't have the time to kind of even get involved with it. But yeah, I mean, kudos to you. There's your shout out.
there you go. Yeah, it's funny because, you know, you don't even know. Like, I knew nothing. I still like, I mean, I got stuff, but again, it's like if you're a lawyer, and probably like there's a bunch of professions. You may be like a doctor, if you're an accountant, if you're an investigator, whatever. You see a fact pattern, and from the fact pattern, you don't have to know everything, but you get a feel, and a lot of times you're correct. And it's just repetition, I think. Just see stuff enough. You may not
Well,
be able to say you may not be able to say why, but you have a feeling.
we both thought something was wrong.
Yeah.
You had the time and wherewithal to dive into it, but nothing ever sounded right with this as we were hearing things. And you and I had those conversations.
Yeah, to be honest, it's much worse than I thought. You know, as it went on, and you know, again, it's kind of funny. I even said, I don't think I used this exact language, but in essence, I said, you know, if you don't take care of this now, it's just going to get much worse, and it's going to be out of my hands. I said it multiple times,
Yeah,
and I
you
didn't
said
know.
it
By the way,
nicely multiple
I
times,
did. I didn't know, by the way,
long before
how it
you
was.
even filed.
I didn't even know how it was going to do that. But again, that's kind of how things happen. And now they're in the same position again. They're really, why?
Right.
What benefit with your garbage case? 'Cause I think you have a garbage case against me. Again, if it was like a great case, okay, but you have a garbage case. So why give me the forum to talk about my case?
Right.
Why? How is that a good logic? Whoever you know, advised or made that decision might be the same person who made all those other decisions for the past 18 months. I don't know. Because again, you know, it just seems like another bad decision.
Right.
And again, seems like wasteful of company assets. And you know, I'm not telling what anybody to do, even though like me, I reached out directly and said, don't piss away company assets, because that doesn't just go with me. That might go with the Nevada action, right? I mean, I did, by the way. I did. I specifically said don't spend on the Nevada action too. Don't pay for legal fees for officers, directors. Don't do that. There's nothing stopping if anybody feels the same. If you don't feel the same, then forget anything I say. But if you feel the same, you, in your logic, you've come to the conclusion there's nothing stopping you from letting somebody know that you don't want the company's assets to be spent. Because what that does is that might impose some kind of obligation or duty on those people at the company to examine those positions and maybe change how they've acted. Maybe. If you're not so inclined, to don't do anything, by the way. Because I know for most people it's difficult, and I understand. I'm not encouraging anybody, and I'm not encouraging anybody who doesn't feel that way. But just to let you know, I put them on notice. I put them on notice as to my action. I put them on notice as to the Nevada action, and that's it. I could talk about the Supreme Court ethic rules, but it sounds too boring, and I've been like droning on too long.
If not at all. No, not at all. Not at all.
Yeah. Anything you want to add? By the way, there's Fox. One thing I listen to is Fox Live on YouTube. And one thing I like at the end of every interview, could be like 9 hours long, they ask, is there anything else you want to add? So, JR, is there anything else you'd like to add?
No, not at all. I think we covered everything we wanted to cover except the Supreme Court ethics rules, but who really wants to hear about that?
I know, it's kind of boring. I agree. That was kind of
that wasn't a good topic.
Yeah, that was like,
I'll tell you what, you got 9 minutes left, fill it with jokes.
Oh, no. But I don't want to end on a sweet and sour note.
Hold on. Someone, M. Casey says she has a request, or he has a request. Sorry. I don't know your gender. Yes, hit the like and subscribe button, people.
Very nice. What was my point about the Olympics? I was saying something about the Olympics, and you cut me off.
I didn't cut you off. You said the word Olympics, and I was like, what is he talking about?
Yeah, I don't remember now.
Hold on. M. Casey, go ahead. What's your request? We're taking requests now to fill time.
Yeah, I was going to say, so as we can we get better?
Can we get a better?
By the way, of those tonight, like I should put up a poll. There were 5 jokes. 2 were original, 3 were not. So if you enjoyed any particular joke, there's something wrong with you, first of all. And then second of all, just note for the record which one it was, and then I'll tell you in the end which one I put in there. For anybody else who has any specific question about what we talked about, because I droned on and on and on about receivership and orders, and feel free to reach out. When this gets posted, just post it as a comment, and I will try to respond, because I do try to respond as many of those as I can.
Yeah.
And reach out if you can, whatever. Anything else that you want to say?
No, I think you covered a lot tonight. So
all right. Okay. So we should have some more information. I saw somebody. So can the receiver quash case against you? Yes. That's an interesting question. I might as well answer it. So could the receiver decide not to fund the litigation against me from gTII? Yes. That might be good for me if we get a receiver, I think.
Yeah.
But on the flip side, I think it's the prudent thing to do anyway. I think it's just people getting pissed. That's why they did it. But it wasn't prudent. Just my opinion. I just don't think it makes sense. That's it. Anything else, JR?
No, I think we're good.
Okay. For everybody out there who listened, I appreciate it as always. Please like, subscribe, share. Again, JR and I are going to end up doing some type of bi-monthly or monthly where we're going to not give, but give legal advice about issues related to people who are following us. And we're going to try to be helpful and provide a different angle. And we're going to try to make it somewhat entertaining, so it's not as boring as like this last 45 minutes of me listening to me.
But we want to try topics that are interesting to people.
Yeah, we're going to try to make it so it's not only interesting, but might apply to a lot of different people, so that everybody can get some value out of it. And we'll try to charge less than $1,000 a month. That's kind of what we're deciding. We haven't quite figured the number out. It's between 1,000 and 999, but we haven't quite figured that number out yet. But anyway, we're going to try to do that and try to be helpful and see if we can provide some value. We try to do that with what we're doing here. It doesn't always happen, and the joke certainly does not. No, that was funny.
No, the jokes add zero value.
Yeah, zero value. I agree. Anyway, I thank everybody out there, everybody who follows us and who watches and who comments and has questions. I really do appreciate it. We appreciate you paying attention.
Yeah.
And if we can help you in any other way, we'll let you know. And I've been yammering on and on and on. Have a great night. Be well and take care. See you later.
Take care, everybody.